Welcome to this Hey Legal exclusive. Content that will keep you up to date and informed about the important legal issues of the day. Time is of the essence, so let's begin.
If we move on to the position regarding solemn business, how effective do you think the working group has been in relation to providing solutions or I suppose just moving the narrative on and creating an environment whereby business can be processed in the High Court?
I mean, I have to be honest, this might not be popular to say, but I think it's been incredibly effective. From the onset, from the point when the working group started, it was, I think, at the second meeting that a decision was made that we were going to get trials up, and Lady Dorian decided that trials were going to get up and running. Mm-hmm. And what you've got to remember is that the purpose in the working group was really to identify the practical means of getting the High Court initially up and running with jury trials. The purpose in the working group was not to decide policy or propose policy. It was really, by that point, there was a number of matters that had been narrowed down, which was, juries with social distancing, whether or not there should be the practicalities of a, 7-man jury or 7-person jury. And given that there was only, 2 relatively short meetings, things get advanced really pretty quickly. And thereafter, what the working group was able to do was really put into practice and come up with practical solutions for the provisions that had been recommended at that point. And once they were focused upon, things moved pretty quickly. And I have to say, the solutions that came out, and having 2 different models, I suppose, you had the 2-court model, which involved the jury watching remotely, and the 3-court model, and having them run in parallel really worked, because you were able to see clearly what the better option was, and clearly the remote jury option was by far the best option. In fact, it was the only option which allowed the trials, if you like, to be upscalable, to be conducted at any sensible number that would allow us to at least get back to some form of normality.
Mm. So where are we? I mean, I've obviously been keeping an eye on this, and we've actually created content on Hey Legal in relation to the Glasgow model and the Edinburgh model. But what I'm not clear about is where we are now at in relation to the processing of business. Is it up and running and using these different models? And the cinema solution has obviously received quite a bit of press coverage and interest. So when is that all likely to start?
Well, first of all, we're not allowed to call them cinema models. I think right. The real title is remote jury centres.
Okay.
But in all joking aside, I mean, what they've come up with is, yes, it's using the cinema building, but for those who are going into it, it will seem like, you're not walking past rows of popcorn or machines. They will be all blocked off, and you will have Scottish Courts signage up. It will appear to be I suppose, an annex of the Scottish Court, which in effect it is. So there won't be that sort of cinema feel. You'll be in a cinema, but having been there and having experienced it, you're not there for entertainment, and that's clear. There is definitely a solemnity about it, which is in keeping with the High Court, and it will be staffed by High Court members. And it is a big step that the government have taken in committing to this, because in effect they're taking over the cinema building from 9 o'clock or 8 o'clock on a Monday morning, and they're not handing it back until Friday night at 6 o'clock. And so for that full 5 days, it is in effect a working court.
Yeah.
Where we are with it is that once the trials the model, the pilot trials were up and running, it became fairly obvious early on that the Edinburgh model was the more successful, because the Glasgow model required more court estate. And it became clear that with the Edinburgh model, with a remote jury, if the jury didn't have to be in the actual courtroom, then there was no need for them to be in the court building at all.
Yep.
And if they're not in the court building at all, that frees up another courtroom. And that means that, in theory, you can run as many trials as you would pre-COVID-19 if you can find somewhere else to house the juries.
Yep.
And, you know, people were a bit flippant about it and a bit sceptical about it being the cinemas. And people said, well, why can't you use theatre rooms in universities or theatres? But the answer is, everything's there in the cinema. They already have the technology. They have an incredible technology, and it's secure, it's encrypted, because obviously cinemas now get films in not through your own actual film that they then put in a camera and play it. It's all done through digital means. So they had that technology there, and it meant that there was a minimum amount of outlay for the Scottish courts for a start, although again they have had to adapt the cinema auditorium. But you'd be quite surprised just to see how few seats you can get in a large auditorium when you apply social distancing.
Right.
And so then there becomes a problem, well, how do the jury, how do they deliberate together? Because you can't do it all spread out in an auditorium. And again, they come up with a solution, and that is just, when it comes to deliberation, the jury will go down and they will sit, as it were, in front of the screen in a sort of a sort of circle, each at an individual table. And again, because of social distancing, it was identified fairly early on that one of the problems was being able to hear properly. You might be 2 meters away from the person to your right, but you might be a considerable distance away from someone else. And they have microphones at the table, so when you want to speak, you press a microphone and you speak. And it was, the working group had a meeting round doing that, and it worked really well. Mm-hmm. And so it's clear that the jury will have that feeling that they are not there for their entertainment, they are there to do a serious job, and that's clear. So far as the timing's concerned, at the moment, the criteria for trials has been fairly narrow, and that was to ensure that we got things up and running and things worked, to make sure that things could work properly rather than come in with complicated trials right away, in much the same way that they cherry-picked for the summary trial, the virtual summary trials. Mm-hmm. And at the moment, we are in a sort of second phase of trials. So there's now 2 in Glasgow per week, 2 in Edinburgh per week. But that will change by about the end of September then. I anticipate that by about the 28th of September, we should be starting the actual remote jury centre trials using the cinemas. That would, starting in Edinburgh on the 28th and starting in Glasgow probably in about the 12th of October. And they'll be getting phased in shortly. But the plan is to fully utilise the cinemas. And the hope is that we will get 16 High Court trials up and running really fairly shortly thereafter. And one can understand why the courts are very keen in utilising them to their full capacity, because they are paying for it after all, and are not in insubstantial sum. So that is the timescale, and my understanding is that the initial contract was for 6 months, but that there will be options to extend that if desired and if required. The other beauty of the remote jury centre is that one of the problems that was identified, it's all very well for the High Court, and saying, well, the High Court, we've got Salt Market, we've got however many courts, and we could do a 3-court model in the High Court and Salt Market, and we could do a 3-court one in Edinburgh. But what do you do with your sheriff courts, where you've got your old Victorian sheriff courts where they're not purpose-built in this way? And it was very difficult to see how you could run sheriff and jury trials using a 2-court or a 3-court model. The beauty of the cinema system or the remote jury centre is that there's no reason why you cannot, in due course, run sheriff and jury trials. Because again, if the jury don't require to be in the building, then you can run it with the trial where you have the normal participants all in the courtroom. And it's really quite strange. It doesn't take very long to get used to having no jury there. Of course, when I say no jury there, they're not physically in the room, but you see them and they see you. And I would encourage any practitioner who gets the opportunity of going along and viewing and seeing how it works to do so, because I would be very surprised if anyone came away and they weren't incredibly impressed by the system and by the setup and by the work and effort and technology that has gone in to make this work.
Yeah. And is there a method that people can do that, to try to get some experience or exposure to it before perhaps then being involved in one of the trials?
Well, again, I think it's something that once, if the remote jury centre comes to the sheriff court, and I think it will, I think it will have to, I think it's inevitable that it will come to it in due course, then again, I think it's important that your representatives, contact Scottish courts and ask if there is a way that they can see the thing working in action. We haven't actually the opportunity. At the moment, there's really only myself and Tony Lennon have actually seen the cinema court option, but we're hoping that we'd be able to arrange a viewing of the facilities for the wider membership. Yeah. And Scottish courts were good enough to arrange that for the remote jury system that was operating in Edinburgh, in Court 3. And I'm sure many of the practitioners will be able to at least go away and go along and have a feel of what it's like in Saltmarket. Yeah. And your jury, where the jury normally sits, now there is a very large screen which is now divided into 15 boxes. It's a bit like a big Zoom meeting. And you're seeing each individual member of the jury. And when you speak to them, when you go to make your speech, you're standing slightly further away, but you are still addressing each individual member of the jury, and they're looking straight at you.
And can the jury see the accused throughout? Is there a camera on the accused permanently?
And again, that was why they had the mock trials, just to sort out any teething difficulties, to see what worked, what didn't work. And initially in the mock trials, the jury screen, the screen that the jury were looking at, was split in two, where you had the accused, you had the accused and the counsel or whoever was asking questions, whether it be defence or prosecution, in one half of the screen, and you had the witness in the other. The jury could see an overview of the court because there was another large television screen in the court, and there was another one with the judge on it. For the remote jury centre solution in the cinema, the very large cinema screen is split into a quadrant. Okay. And from memory, in one you'll have the judge, and another you'll have the accused. The accused is permanently on view, and in another you will have the witness and the whoever's asking questions. Okay. And if you need to look at documents, that can be put up on the screen. Again, that's done on that one screen. Right. And again, that's all been tried and tested and works incredibly well. And in fact, in many ways, the jury get a better view of proceedings than they do from sitting in the jury box, where, for instance, those who will know what like it is being a jury in Aberdeen High Court, for example, the front row of the jury can hardly see anything because of the height they're at, and they're having to look straight over the back of the accused and of counsel. And if the witness chooses to sit down in the witness box, it's almost impossible for the front row of the jury to see. The one thing that you have to be careful about, and the one thing that will change, is that the acoustics and the technology is so good that you cannot whisper even to your instructing agent, and take instructions from the accused in the jury box, from the dock, is impossible, because the system picks up even the slightest whisper. So if you have to take instructions in the course of a witness giving evidence or anything, of the accused makes it known that he wants to give instructions, you really have to have a short adjournment to do that.
Right, okay.
So the days of counsel and solicitors sitting and making asides to each other, I'm afraid, for the moment, are gone. Because if you do, they will be heard by every single member of the jury.
Okay, brilliant. And I'm not at all being flippant here, but was it ever suggested that there could be Saturday courts for the solemn business?
Well, of course, that's not too radical. It wasn't. I mean, it was before our time, but it used to be the case that once a trial started, a solemn trial started, it ran till it finished, and the only day it didn't sit was a Sunday.
Yeah.
So I think at the time when the manual trial was the longest in Scottish League, I think it might have been the longest in history. I think it only lasted about 2 weeks or 3 weeks. They sat on Saturdays. So, but to answer your question, no, I don't think it was ever seriously suggested that happened.
Okay. And
but
so
again, you see, that would be a problem for the jury as well. And in fairness, again, I don't think there's ever a suggestion that, even in the sheriff courts, that solemn trials would sit on a Saturday.
Yeah. No, it is problematic, and obviously some of the similar principles apply. Even if it is summary business, it's still difficult for witnesses or whoever it will be to commit to a Saturday to come to court, and perhaps there's obviously family needs or whatever arising at that time, or just leisure. But I think that's great, Ronnie. Going forward, though, we talked before we started recording about maybe the challenges that perhaps lie ahead for the profession as you see it. So could you outline what you think the pressing issues that are coming onto the agenda?
Well, I think the most obvious one is what's the profession going to look like at the other end of this pandemic? And we were talking about this earlier. When I started, there was always it can't get any worse than this. This is, this is a disaster, whichever change there was in the legal aid regulations. I think this is definitely the most serious threat. And the question, I think, is how many firms are going to be left at the end of this? And I know that there have been various, I don't know if there's been a survey done in Scotland. I know that there have been surveys done in England, and the results were really quite frightening. And that also applied to members of the bar. There was one survey that said, do you still see yourself in business if this lasts 6 months? What if it lasts 9 months, and what happens in a year? And it was something like 88% of the bar said if it lasted a year, they wouldn't be in business. Yeah. And I think it was something like 75% of firms who were engaged in legal aid work said that they did not think they would survive if something didn't happen. So I think, I hope I'm wrong, but I think there's a real risk that the profession will be leaner at the end of this than it was going into it. Now, there's always an argument then, those who are left will be stronger. But that really cuts down the choices of the public, and it really does restrict access to legal aid. And I think that is one of the main problems that not only the profession faces, I think society faces. We discussed that as well. Lawyers get a bad name and we're always unpopular until someone needs a lawyer. And then very quickly they realise the worth and what we do provide. I think one of the challenges I do think will be whether or not the provisions that are brought in order, we are told, to get through the pandemic will still be kept on at the end of the pandemic. And I think in some ways there is a threat to oral advocacy, for example, the way we do our business. And don't get me wrong, I understand there's always an argument in every branch of society and every professional about, things are cheaper. And if it can be done cheaper, then why don't we do it cheaper? But cheaper doesn't necessarily mean best by any means. And I think, and that was one thing that we tried to get throughout this whole process, and we repeated it more than once. Convenience shouldn't trump justice. Just because something's cheaper and easier, well, that doesn't automatically mean that that's what we should be doing, and that shouldn't be the default position. And for example, the suggestion in Sheriff Pyle's report that after 3 pilot trials, only 2, I think, which actually went to completion, which were cherry-picked, both by the Crown and the Defence getting together and identifying them, that after that short experiment, that should be the default position.
Yeah,
I find that worrying, because again, that in some ways doesn't address the practicalities and the difficulties that we know there would be in conducting the vast majority of summary trials that way.
Yeah.
And so, yes, things that have been brought in order to get us through this crisis. My view is that doesn't, just because they got us through the crisis, doesn't mean they should be retained when we come out the other end. Yeah. And I think that's worrying for things like summary trials, because we all know, and we're told, well, no, it doesn't make much difference. But how do you read a witness? How does a sheriff properly read a witness's body? I mean, juries are told all the time that you can take into account the demeanour of a witness, their body language. Well, it's very difficult to do that on screen. So I think certainly those things that have been an improvement, then fair enough. But I think there should be discussion amongst the profession and the courts about what does work and what doesn't work. And by what does work and what doesn't work, I mean what does work and doesn't work for everyone, not just one particular branch. Well, it works for the courts, so we should have it. It works for the Crown, so we should have it, or it works for the Defence. I think there are serious discussions that need to take place. But in order, and again, it goes back to this, but in order to do that, I think the profession has to be organised.
Yeah. Yeah, I mean, I think when you read through the Respond, Recover, Renew paper, obviously, the most efficient way to deal with backlogs, obviously, to have no juries. But it's not about efficiency. This process isn't about efficient processing of business. It's about achieving just outcomes, and obviously to remove a jury for even a period, and then come to the point where the pandemic's under control or whatever, then it is something that could be lost if there's not a great deal of caretaking.
Absolutely, and I think that was a fear, and I think it was one of the things I said at the start. One of the fears was that we say, well, let's bring it in order to get through the crisis. And you bring it in and then the crisis disappears and someone says, well, in actual fact, why don't we just keep it? Yeah. Because, it worked, so we'll just keep it. But just because something works doesn't necessarily mean it's the best way of doing it. And it might work to a minimum standard, but that's not what justice is about either. It's a bit like human rights. There's a minimum requirement, but that doesn't mean that, well, okay, we'll just do everything utilising the minimum requirement. It has to be not only what works, but what works best. Yeah. And to take away from the public and from society that critical right that they have in order to sit in judgment of their fellow citizens, I think it's crucial. And it's just my personal view, but I do think removal of a jury system in an adversarial system is a threat to democracy.
Yeah, absolutely. Absolutely.
And although some people thought we were, perhaps dogmatic about it, I don't agree with that. I think it was a matter of, it was a fundamental principle. It has worked for 600 years. It's been the mainstay of our criminal justice system for that period of time. It should not have been the first thing. It shouldn't have been the first victim, as it were, in the pandemic. And that was why we were concerned when we were being told, well, look, it's the last resort. You know, we'll do it just to get through this pandemic because it's the last resort. It's a last resort. And our view was, well, how can it be a last resort when we haven't tried anything else? A last resort is normally that, when you have tried everything else and everything else has failed.
Yeah, very much so. Yeah, it's a line that can't be crossed, absolutely. Well, Ronnie, thank you so much. You've been very generous with your time. I'm sure you've given lots of updates to many who have not known exactly what's going on or what lies ahead. So thank you very much for that. I wish you good luck in relation to what lies ahead too.
Thanks very much, Ali.
Okay, thank you.
Cheers.
We hope this Hey Legal exclusive content has been of value to you. Hey Legal exclusive. Follow us please on YouTube and Twitter, and create a free account on our website to stay informed and entertained about Scottish legal matters as they happen.